The district attorney addressed everybody, so you're familiar with what transpired today, so I'll let you ask the questions. I'm happy to answer them to the best of my ability.
Your take on it.
Is it recording?
Are you disappointed?
Thank you.
That must be the 14, that's why.
Your take on the case is not being severed.
We made a motion, we had faith in our arguments, we think we were right on the law. Ultimately, it's up to the court to make that decision. Judge Mazie didn't agree with us, we move forward.
Are you disappointed?
Yeah, listen, we don't make, Ms. Koish is a phenomenal writer. And she has written 3 extraordinary motions. One of them is the DNA closing brief, if you will, on the Fry hearing. She made a motion to sever. She made a motion to preclude the evidence because it doesn't comply with the public health law. We're not wasting people's time. We're not making motions for the sake of making motions. We're making motions because we are confident in the law and confident in our position. Ultimately, we do not make the decision. That's up to the judge. The judge ruled against us. We don't like the decision. We don't agree with the decision. But in our system, we accept the decision and we move forward. That's how our system works.
Mr. Brown, we thought that all the discovery was in a couple of months ago, and now it seems like all this new stuff has been presented. How much do you have to go through, and what do you think you'll have to make motions on?
Well, they certified a week ago, so certainly the discovery was not in months ago. They had certified saying that we now have all the discovery. And listen, I think we can all agree, both the district attorney's office and our side, that even more things would trickle through as we go forward. I think that's clear. But the bulk of what they have has now been turned over, is what they have certified to. We're going to continue to review that. This is a mountain of mountains. You got to remember, we're talking about 30 years of investigation. We're talking about 7 victims. So it is an enormous amount of discovery. We're continuing to go through it. We will make the appropriate motions. I'm confident in Ms. Koish's ability to make subsequent motions. It's going to be up to the court to decide those motions. We're batting 1,000 right now, but we're going to keep going. We're going to keep fighting, and we're going to keep making the appropriate motions, and we'll let the court decide accordingly.
Any truth to the speculation that Mr. Heuermann is going to plead guilty?
I'm the last to know if that's the case.
I've been a rumor been going around. Rumors been swirling around.
You know what they say about rumors, so I'm the last to know.
As his attorney, why would you be last to know?
Probably because it's not true.
Does Rex feel this was a setback?
I'm sorry?
Does Rex feel this was a setback?
We didn't really have a significant conversation. You know, we got the decision in chambers. I handed it to him. We had a brief conversation with him in the back. We moved forward.
But you indicated you would file at least one more additional motion in January. This is what the judge said. What would that motion be for?
Well, there's a lot of search warrants. So there's a lot of search warrants in this case which we're going to attack. And there's also the inspection of what's called the grand jury minutes. Several of the victims, the grand jury presentation is really bare bone. And we don't believe that there's reasonable cause or probable cause that was presented to the grand jury on 2 specific victims. At a minimum, so we're going to attack that as well.
Which victims are those?
They'll be forthcoming.
And Rex's mood right now.
Well, you have to remember something. He has maintained his innocence from day one. He's been in custody since July of 23. This was an individual who was married. He has children. He was working. He goes to work every day on the Long Island Railroad, commutes into the city, makes a living, supports his family. So you take his custody away and his liberty, and he's in a cell and contemplating the rest of his life, maintaining his innocence, and wants his trial. So he's doing the best he can until we get to that date.
Mr. Brown, when this all started, did you think this trial would move into 2026?
When it first started, on the day he got arrested, or in that first month or so?
When he got arrested?
Yeah, I didn't know what to expect at that point in time. I didn't know the mountain of evidence. I didn't know the voluminous amount of discovery.
But then as you gathered some of that evidence and discovery, did you think it would move into 2026?
As I gathered the evidence and saw the discovery, I thought it would go into the next decade, quite frankly. I didn't have an idea of when, but I knew it would be a significant amount of time.
Are you expecting any more charges?
I'm not expecting any more charges, no.
If you could look forward, I apologize, but if you were to guess in your professional opinion of doing this a while, when do you think trial will begin?
Well, I think we can guesstimate it would be sometime in the late part of 2026. If you look at the schedule now for motion practice, the judge put it over till January of 2026. We're going to continue to review the discovery. So I think sometime towards the end of 2026 would be a fair guesstimate.
Thank you.
What kind of conversations about, not that you can speak directly about it, but he's saying that he wants to go to trial, he wants to go to trial, he wants to go to trial, you keep saying we have to go through our motions first. How do you explain that to him, to know that, you want to go to trial, that years and years and years?
Yeah, it's somewhat competing interests, because when you have a situation like this, you have an individual, a client who says, I didn't do this, I want my day in court. And then you have the attorney saying, well, we got to do our due diligence. In order to get to that point, we have to do everything that we need to do under the law on your behalf. So that's what we've been doing. And he has to understand, and he has, that we have to do our job to get to that point. So it's all the preparation to get to the final point, which would be a trial, a jury of his peers in a courtroom here in Suffolk County.
Hi, Brendan Cruz from the New York Post. So, given today's setbacks, what's the next step for the defense moving forward in terms of how you're preparing for trial?
So, as indicated, we're going to go forward with motion practice, additional motions. And listen, we talked about setbacks. But when you look at the big picture, number one is, yes, that DNA evidence is now coming into trial. That's what the judge ruled, subject to the foundational requirements. So the whole genome sequencing and the IVD gem, which we still maintain as magic, that's going to be introduced at trial. But that doesn't mean in any way that we're limited in attacking that before a jury of his peers. In fact, we are going to attack that, and we have additional information to attack the whole genome sequencing, and more specifically, the IVD gem. So that's still a significant issue. But it was a threshold issue, the Fry hearing was, to determine if this even comes into play. Again, we lost that. We disagree with the court. That means it's going to be introduced during the course of the trial, but it's subject to cross-examination.
And what are the what are some of the things that you're looking for in the motions that you're looking to put forward?
Well, we have motions to suppress some of the search warrants. We certainly will pursue that. And that means that some of the evidence that the prosecutor and the police department may have obtained was illegally obtained. That's number one. The other thing I had mentioned is the inspection of the grand jury minutes. So if in fact insufficient evidence was presented to a grand jury to get some, if not all, of the indictments or the counts in the indictments specifically, then those should be dismissed pursuant to the law, and then we're dealing with less counts at trial.
Mr. Brown, how are you going to further attack that DNA technology in front of the jury?
Well, if you folks listen to the witnesses at the Fry hearing, all of the things they said and all of the cross-examination, that's all game for trial. That's all subject to cross-examination. And again, the judge, it is a threshold issue whether or not that's able to get to the jury. But once you get to the jury, Jurassic Park and all the other things are still going to be presented, and they're still subject to cross-examination. And again, the general acceptance in the relevant scientific community, the only person who has acceptance of this new science is Dr. Green himself. That's it. There's nobody else on the face of this planet that uses IBD gel. Again, the court disagreed with us, but that's for a jury to decide whether they're going to give it any credit during the course of the trial.
So Ms. Coyce gave a very impressive dissection about the IBD gem at your side of the Fry hearing. I presume we're going to see more of her doing more of that?
We want to have her do as much as possible. She did a great job at the Fry hearing. I thought we won the Fry hearing.
And so now it becomes, I presume, an instance where you're trying to convince the jury of what you all believe, rather than trying to convince the judge of whether or not that's it or not.
Yeah, let's remember, the burden on this case is on the district attorney's office. They have to prove their case beyond a reasonable doubt. And all the same evidence that they put forth at the Fry hearing, they're going to put forth before a jury. And all the questions that we asked are going to be put forth before that jury too. I stand on what I said. I think we prevailed in the Fry hearing.
Can you elaborate on the search warrants you intend to attack?
Not at this point, only because, I don't need to interrupt, but
Okay.
just because it's a little premature. We're in the process of reviewing those, and we're going to continue to review those. And certainly, once we have the papers, Ms. Koish will share those with you, but we're not going to get into the specifics at this point.
Is there a rough date as to when you expect to file these motions?
Ms. Koish wanted to add something.
Yeah, I just want to say to the really important part about the positions and laying out the legal arguments, even though Judge Macy doesn't agree with our position, there may come a time that if we're not successful at trial, that the appellate division judges are going to review this. And they're going to review the Fry case, and they're going to review the permit issue and the severance issue. So it's really important that at this stage, we make all of our legal arguments and that we preserve them for further appellate review.
If the whole genome.
And let me just, I'm sorry, let me just say that, we'll get to that, I promise. Let me just say this, and what Ms. Koish said, so this was a case of first impression in New York State. So, okay, we have a decision, the judge ruled against us, and the prosecutor's very excited, and look, we're right, so says one judge. It's a case of first impression. So, as Ms. Koish said, a panel of judges in Brooklyn and potentially a panel of judges up in Albany, if we're not successful during the course of the trial, they have the opportunity to review all this. So just because one judge, and clearly I have the ultimate respect for Justice Macy, but if he was wrong, they can overrule that decision. I'm sorry.
Now, if the whole genome sequencing didn't get in, would there be any valid DNA evidence?
Well, yeah, I mean, remember that the prosecutor has mitochondrial DNA, and that's something they've had from the beginning. The whole genome sequencing DNA just kind of, and this is really our big problem with it, it puts the statistical likelihood ratio off the charts. So you have the mitochondrial DNA, and I think it was 1 in 10,000, which when you put that in perspective is not very convincing or compelling. And then all of a sudden they had this whole genome sequencing, and the IBD gem, which initially mitochondrial was 1 in 10,000, and now you have 1 in a number none of us can fathom. And that's because of the program IBD gem, and that's because it just is not based on science. But we'll leave that to a jury.
Thank you.
Mike, Mr. Tierney said that these cases with all these charges are inextricably linked. Why do you feel that they are not?
We laid it out in our motion papers. Some are, some aren't. You know, the MO is similar in some, and we conceded that. The MO is not similar in some of the others. It's in the moving papers. The judge didn't agree with us. We moved forward. Okay, any other questions, guys?
Can you just ask me, I know you're not going to go into the specifics of them, but when can we expect these additional motions, about the search warrants to be filed?
The judge set the deadline of January 13th. We're going to do our best to comply with that deadline. We work, and hopefully we can have that done.
Okay, thanks.
Thank you.
Thanks, guys.